Hello everyone, welcome back to my channel. Don't forget to like, comment, and subscribe. Maritime Law, right of crew and seamen to receive maintenance money. This article was written by Elias Rudnikas. Okay, what is maintenance? All crew members and seamen have the right to receive a daily amount of money when they are unable to work because of an accident, an injury, or a sickness that occurred while working or in the service of the ship. Service of the ship includes maritime injury and sickness that occur while traveling to and from the ship, while on shore relief, and while working on land or on an island of the ship. What does this mean for a crew member or seaman working on any ship? It means that if a crew member is injured or becomes sick while working or in the service of the ship, the company has to pay him a daily amount of money until he reaches maximum medical improvement. And then, what type of injuries or sickness entitles the crew member or seaman to maintenance? Well, the injury or sickness doesn't have to be related to the crew member's occupation on the ship. It doesn't need to be a result of a cruise ship injury or other maritime incident. Or other maritime accident. For example, a crew member is entitled to maintenance while receiving medical treatment for a heart problem, a kidney problem, diabetes, a mental problem, or any other medical condition. And then, is a crew member or a seaman entitled to maintenance while hospitalized or living in a company-paid hotel? And the answer is no. The purpose of maintenance is to pay for the crew member's living expenses. If a crew member is hospitalized or living in a company-paid hotel and he is receiving room and board, this fulfills the company's obligation to provide maintenance. And then the next, what determines how much maintenance money the crew member or seaman receives? In most cases, the daily amount of money you will receive is determined by the employment contract that the crew members sign or by the collective bargaining agreement. And then the next question, for how long is the crew member or seaman entitled to receive maintenance? For as long as he is receiving curative medical care, the company's obligation to pay maintenance only ends when your doctor says that you can return to work on the vessel or fit for duty, or he says that you have reached maximum medical improvement. And then the next question is, what does maximum medical improvement mean? Okay, maximum medical improvement means that, in the doctor's opinion, any additional medical treatment will not improve the crew member's medical condition. Of course, with most serious injuries, a crew member may have reached maximum medical improvement but is not fit for duty. And then the next is, what should the seafarer consider before hiring a maritime lawyer? In the age of globalization, cruise ship companies seem to have almost unlimited leverage when it comes to setting the term for employment, wages, and working conditions. Fortunately, seafarers are not always at the mercy of these employers. As long as they are aware of the rights and what they can do to seek the redress they deserve. Many crew members are not aware of their full rights and protections, and as a result, can be taken advantage of without them even realizing it before it is too late. To help remedy this situation, attorney Elias P. Rudnikas provide free legal advice to all crew members. And then before hiring a lawyer, it is best to sort out what kind of legal problem you have first. This will determine which country the lawyer should be licensed in and what legal field of expertise he or she must have experience in. For example, a seafarer who is charged with a crime and needs dedicated defenses would need a criminal lawyer that is licensed to practice in the country where the charges were brought up. Seafarers can write to attorneys Elias P. Rudnikas should they need clarity on the type of legal issue they have and what kind of lawyer they should hire. Once the decision to hire a maritime lawyer is made, the claimant must act quickly since there is usually a time limit for filing a case. In addition, the lawyer should explain the following. The first, what option you have for solving your problem. And then the second, what are your chances of winning or getting a settlement? And then the third, how long your case will take. And then number 4, if you have to pay, should you lose the case and how much? And then number 5, what kind of payment arrangement he or she will accept. Again, the next explanation is about why is it so difficult to know which maritime law applies. Many factors come into place when deciding what maritime laws are appropriate in each case. Among other things, one factor to consider is the location where an accident happened. Did it occur in territorial waters or the high seas? The flag of the vessel in which the incident happened is also important. Even the location on board the ship is often established within given applicable contract. And whether an incident occurred in a public passageway or in areas given over the operation of the ship can be relevant. Further complications arise from the fact that passengers and crew are often from different countries with differing languages, cultures, and laws. These difficulties are often used against passengers and crew who feel as though their rights are quickly disappearing. Although workers and passengers may feel helpless, it's important that they understand that their right can be asserted. And then the next, let's take a look at maritime law and the Jones Act. After exposing some of the problems of maritime law, it is important to be aware that it is possible to claim compensation for damages. To cite one example, the Merchant Marine Act, known as the Jones Act, was passed by the U.S. Congress in 1920 and protect both U.S. and foreign-born sailors. Mariners can claim injury compensation provided that their employer has not provided a safe workplace. An accident claim may have not even originated on the boat. The Jones Act protects employees from marine employer negligence, however, minimal. Not only sailors are protected by maritime law, disputes arising out of the business relationship between passengers and cruise companies can also be argued within the framework of maritime laws. Several reports of sexual abuse on cruise ships and disappearance cases involving persons at sea have been uncovered. where often people were not aware of the existing maritime laws created to protect victims of just such cases. Okay, that's all for today. Thanks for watching. Don't forget to like, comment, and subscribe this channel. See you in the next video, and bye bye.